Good morning. Welcome to Member Focus Monday. I'm Christina Schaefer, Director of Social Media for HAR. We have a legal panel this morning. We're excited to hear from you both. This morning, we're actually joined by NAR General Counsel Katie Johnson and HAR's legal counsel, who's no stranger to this program, Grant Harpold. Welcome to you both.
Good morning.
Thank you, Christina. Good morning.
Thank you both for taking the time to be with us this morning. And we'll talk about it. Katie, I'm sure you're about to tell us about it, but there's a lot going on with different lawsuits, different legal questions. So we thought it was a good time to have you both on to get a local perspective from you, Grant, but also a national perspective from you, Katie. So before we get into that, if we could, just some quick introductions, if you both could tell us a little bit of who you are and what you do. And we can start with you, Katie.
Sure. I'm Katie Johnson. I'm the General Counsel and Chief Member Experience Officer at NAR. So in addition to everything legal, I get to work on all of the membership programs, the outreach efforts with associations and members. And I'm coming at you from Chicago, Illinois, in my basement.
Let me say that Katie's the best. So I'm very honored. I think we're all honored to have her on here with us this morning. And I'm Grant Harpold, legal counsel for HAR, sitting in my office and happy to be here.
Absolutely. And a comment just came in from our president and CEO, Bob Hale. Katie and Grant, two superstars. And I definitely agree.
Hi, Bob.
Yeah.
So if we could, I guess, just jump right into it, starting with you, Katie, there's a lot going on, as we mentioned. If you could give us a brief overview of, the lawsuits that NAR is currently facing, because we get a lot of questions about this here at HAR.
Sure. And there are a lot of lawsuits to be talking about, unfortunately. But most of the 9 lawsuits that NAR is currently defending boil down to this. They boil down to certain plaintiffs alleging that the NAR rules, specifically MLS rules, result in higher commissions being paid to our members and lower services being delivered to consumers. The first 2 class action lawsuits that we started defending in 2019 purport to represent a class of sellers who allege that the participation rule, the cooperative rule of the broker cooperative MLS system, in which the listing broker offers to compensate the buyer's broker. They allege that that rule and NAR practices or member practices has resulted in artificially fixed and inflated commissions being paid to buyers because the sellers are paying the buyer's representative. Those cases allege that if the buyers paid the buyer representative directly, that the commissions would be lower because buyers would negotiate it lower. Those cases allege that buyers' representatives don't deserve the commissions that they are earning because homeowners find all they need to know on the internet. Thus, the services being delivered are lessened in this internet age. They allege that members misrepresent their services as free and thus confuse consumers as to the negotiability of commissions. And they allege that the international markets that don't have a multiple listings supposedly have lower commissions, and thus there must be something wrong with our MLS system. So those cases are wrong on the facts, wrong on the law, wrong on the economics. We will defend them, but more have spawned out of them that our members should be aware about. And specifically, those were seller representative cases. Now we're also defending buyer representative cases where they allege all the same allegations that I just said, but also that buyers are harmed because sellers are only willing to accept higher home prices in order to pay the commission.
Okay. Well, thank you for clearing that up and kind of explaining where we're at, because again, we see headlines, members ask questions, and so just getting an overview of what exactly is going on from you is really helpful. In regard to the rule changes required by the Department of Justice, some members have questioned the access to lockboxes and are seeking clarification. Can you tell us a little bit about that and then just kind of let us know where are we on that?
Yeah, sure. So I just spoke about a handful of class action lawsuits that we're defending. And as you just stated, in November, we settled a lawsuit with the Department of Justice. So we began the settlement process with the Department of Justice. And very notably, the Department of Justice reviewed our rules, all of the rules, MLS Code of Ethics rules. And as a result of that investigation, we will be eventually asking members for 4 rule changes. Notably, we are not being asked to change the participation rule, the offer of compensation that's at issue in the other litigations that I mentioned. So those 4 rule changes, very quickly, are to disclose commissions, so that MLSs will now publish the offer of compensation in the listing detail page in order to ensure that buyers are aware and knowledgeable of the offer, the amount that their representative is being offered compensation. There's going to be a ban on offering services as free. You cannot advertise that your broker representative services are free if you're being paid by another source. There's also going to be a prohibition on filtering listings that get to the consumer by the offer of compensation or by the name of a broker. And that's an attempt to make sure that the consumers are receiving all possible listings that match their criteria and their needs. And then finally, as you mentioned, the lockbox rule. The lockbox rule is really a variation on a current obligation, the current obligation being Article 3 to cooperate with all brokers, period. As long as it's in the best interest of your client, realtors have an affirmative obligation to cooperate with other brokers, meaning to share information about properties and to share access to properties, regardless of the broker's membership status in your organization. So this rule would further enhance that obligation by requiring that the lockbox be accessible to those brokers as well. And we have suggested and requested to the Department of Justice that be accompanied by reasonable restrictions regarding safety and administration and cost of making that access available. So where are we? Good question. Department of Justice, where are we? No, we have delivered the draft rules to them. We are in the process of negotiation on the final language. And as soon as we get that completed, we will bring it to our NAR Board of Directors for approval. I'm hoping that'll be in May, but we'll see how the negotiation process goes.
Okay, wonderful. And thank you for clearing that up. Again, we get questions from members, and a lot of times we get those questions from members because their clients and customers may see a headline and ask them. So to that point, what would you suggest a realtor say to a client or customer that may ask about the lawsuits? And also, is there anything that realtors can do to educate themselves and their clients better?
Yes, I implore members and multiple listing services and realtor associations to talk about what matters, and that is your value. If there's anything to be gleaned from this litigation morass, it is that we could do better educating consumers on what realtors do and how the MLS works for them. Multiple listing service obviously being the a critical fair housing tool that works for both sellers and buyers. And that just needs to be explained more, and the commission structure needs to be explained more. So we created a lot of helpful tools for doing that. I shared with you, Christina, links to our member messages. We have talking points on our website. We have infographics about how the MLS works, infographics about why buyer, the economics of being a buyer in a home sale, and other information that's going to help members have these conversations about what really matters, as opposed to the procedural history of the litigation itself.
Excellent. Thank you. And we are sharing those links in the comments. So if you see those pop up, you can take a look, click on those and save them for later. And I would maybe bookmark some of them as far as those member messages. So Grant, I'd like to talk to you about some things that are going on here locally. We're dealing with a very busy market, as you know. Are there any potential legal risks for members when you're dealing with a market like the one that we're currently in?
Yeah, let me just add something to what Katie said too, that they did have a good victory. I don't know if she mentioned that in California on the clear cooperation rule. getting that lawsuit dismissed and making that rule pretty effective, and a very sound, reasoned opinion from the court on the enforcement of the clear cooperation rule. So that was a victory, Katie. Right, way to go. And so
Yeah,
they may
thank you.
appeal
I
it, but
did forget.
yeah. Here locally, I think, when we're in a market with tight inventory and very aggressive selling and buying going on, you have to take a pause a little bit, kind of slow down, remember your ethical duties to your client. It's okay to be aggressive and to represent your client, but don't represent your client to a detriment to your client. So just, you may want that property, your client may want that property, but just remember your code of ethics, your responsibility. And remember, it's not about you, it's about the client's interest first. So don't try to be a hero, just do your job and maintain your view of the big picture of what's going on, and not try to just get a quick victory and to the detriment of your client. So I think that's really kind of what's to keep in mind, at least here locally.
Yeah, I can see that. Yes, Katie.
Yeah, no, I totally agree with Grant. I always do. So great advice, Grant. We have, speaking of the clear cooperation policies, I mean, that is, thank you for bringing that up. Those are two other lawsuits we're defending from others who are attacking the MLS system in a different way. But, in this hot inventory market, that is when people tend to think of alternative ways to keep the listings close. And as Grant said, you have to put the consumer's interests first and foremost, and mostly for most sellers, that is to expose it to the widest audience possible. Thus, the clear cooperation policy makes sense. It works. I just also would add that on NAR.Realtor, and Christine, I'll share this link with you afterwards. I forgot to share it with you now, that we have also talking points for consumers about multiple offers. We know that is a very intense and stressful situation when you're faced with multiple offers. So we have this guide for talking with consumers, either the buyer or the seller, at the outset of the representation, early on, to prepare them for that potential situation, and to give them their options to be thinking about, so that they're not just overwhelmed in the moment when it happens.
Excellent.
So NAR.Realtor, search multiple offers and you'll find it.
All right. And I'm sure we can find that and put that in the comments as well. So again, we're seeing a lot of different things going on with this market that we are in. And we've been hearing a lot lately about what people call the buyer love letters. And everybody has a different opinion seemingly on it, but I'd like to get kind of your legal opinion on it. And Grant, we can throw this to you. What legal risk might come from those, and what can realtors do to kind of avoid that risk?
Well, I think as a general rule, the best advice is not to do one. And so from the buyer side, no, and from the seller side, we're not accepting them. And so the risk is that you're putting your client, whether you're the buyer's side or the seller side, into a position or into a light or into a view or into how somebody looks at them that they might otherwise not look at them in that manner, whether that's intentional or unintentional. So if I'm explaining myself to a seller as a buyer, it may put me in a light that really wasn't the light I thought I would be reflected in. And from the seller side, same thing. I may look at this letter and see some identification, some fair housing type identification that unintentionally or intentionally causes me to, as a seller, make a decision to not sell this property or not continue in this conversation with this potential buyer. Mm-hmm. And so I think as a general rule, stay away from them. And you may be in that situation where there's my buyer's insisting on it, my client's insisting on it, the seller hasn't said anything. What do I do? I still think you stay out of it. You don't tell them how to write it. You don't help them write it. You don't review it. You may not even deliver it. As a general rule, if somebody were to write a letter, I mean, you really should focus on the property and not yourself. I mean, so property specific, but that's, like I said, that's a very far exception to what I think is the best general rule. And NAR has some great information on this, on viewing this, and well articulated and very reasoned out as to why you should just stay away from them in general. Right, Katie?
Right. We've got a resource on every topic that you'd be interested in. But yes, we do with buyer love letters. And Grant's absolutely right that the most conservative and risk adverse approach would be to not have buyer love letters. We understand that they are used properly. So we're saying that, and yet they're still happening. So yes, please follow Grant's advice to not include anything about your personal characteristics in the letters if your clients do that, and to focus only on the property and the qualities and characteristics of the property and why they might be a fit for you. If you must do it. But ultimately, we need to work with, this is a charge to the listing brokers. Mm-hmm. The listing brokers really need to work with the sellers and talk them through this and as to why they should not accept it. If they won't accept it, then they go away. If the sellers don't want it, then they go away. And that is going to put everybody in fair footing.
Definitely. Just a couple comments rolling in from our members. Lisa said, how would the letter be different than them meeting in person? Not the ideal situation. And Kimberly just made a comment. Yes, please stop sending these. Many sellers don't look fondly at these. So Grant, you actually made a good comment, which is you can put up, we will not be accepting any buyer love letters. So that's a great suggestion.
You can control that on the list side from the very beginning. Or if you don't from the beginning, at least if it's suggested that one may be coming, no. One, don't send us one. And if you do at that point, maybe maybe again you're putting your client in a look that isn't the best look for the seller side. So so that's the problem on the buyer side, is not only just painting your client perhaps into a corner that was unintentional and not expected, and so. And the buyer needs to be aware of that, and you as the agent also.
Yeah.
And by the way, the in-person versus the letter. I mean, the letter kind of spells out the emotional side of this, and that's what's in the sort of tying it back to you as a person and why me wants his property. I mean, that's the danger in these letters, and that again, that's what puts you into perhaps a box that you were not intending to be in, and sort of boxes a seller also.
And remember, it's just one tool to reduce risk of violating the fair housing laws. And you're right that meeting in person will give you some idea as to some of the protected qualifications, identifications that are apparent by view. The internet too, looking at people's social media pages, that will give you more information. And so people say, well, why not the buyer love letter? It's an additional risk. It's just an additional way that the seller could use the information gleaned in the letter against the buyer, and therefore discriminate based on whatever they say in the letter. So good point that you can glean information about people so much more now than ever before. And not using those letters is one way to reduce the risk of violating the fair housing laws.
Very good. We have a few questions rolling in about this. Alverna said, same question regarding character letters on leases. So what are our thoughts on character letters when it comes to leases?
I think it's the same sort of issue. Whether it applies to a lease or a purchase, it's back to promoting yourself, and from the buyer side and the seller looking at the promotion of yourself perhaps, and making a decision unintentionally or intentionally based on what you've said in a letter about yourself. And that's typically, if you see a standard love letter, it's about why we want this house, and that's the danger of pursuing it in that manner.
Okay, very good. So Leah asked a question: should leasing agents also not send driver's licenses in the initial lease application? I think that the question there is because you're seeing a picture of somebody and you can make assumptions based on some protected classes.
No. So again, I think that the driver's license identification of an individual is almost always required for any contract that you're going to pursue. And again, race is not the only protected class in the fair housing laws. And so if you're only, you must share driver's license or identification information. The risk is going beyond that when you talk about other qualities and characteristics that the buyers may, or the sellers may discriminate upon.
Okay. So there was another question here, Stephen, and this is again taking us back to a lot of these questions come in because they are, their customers or clients ask them for these things. So Stephen says, wait, if we are fiduciary to our buyer and they want to write a letter to the seller, can we really stop them?
No. I mean, no. And I think we touched on that. I mean, you provide the advice. Look, Katie and I are lawyers. We give advice a lot, and sometimes it's not followed, and that's okay. Right, Katie? I mean, so if you give advice and it's not followed with that, that's okay. That happens. That's the real world. It's probably best if you give advice and it's not followed, that you document that somewhere in a confirming email or something that you can say, yeah, we discussed this, because exactly what has happened now is what I told you could happen when I said don't do it. So
and I just to add to that point, to Stephen's point, as the fiduciary, you're bringing the risk, you're making them aware of the risks and the potential outcomes, and so that's a good thing to have these conversations and to even advise against it if you think there's a risk that they would be discriminated against based on the information in their letter. Can you stop them? No, because people have free will and they'll do what they'll do. But you, as their fiduciary, have been their advisor and given them good guidance. And documenting it is always a good idea, as Grant just advised.
Yes, absolutely. So a longer question here from Oya. If a buyer wants to terminate due to lender's appraisal and send notice and request a release of earnest money 1 week before closing, can seller adjust sales price to lender's appraised value and still close on time? If buyer still wants to withdraw, is it a breach of contract?
Well, I guess I would defer to what the contract says. That was, I understand where they're going, but on anything of that nature, it was whatever the terms in the contract say. So whatever it allows you to do, of course you can do. I'd have to look at it on a case by case basis.
Okay. So, and then there was a comment here about leases. I believe lease approval is based partly on credit profile. So, again, you guys are basically saying that that's going to be required in a lot of cases.
Yeah, and it's a good question. And it reveals another area of needed improvement in the fair housing realm. On April 8th, we just had a webinar that people can still view on our website about credit scores and credit profiles and how there is some bias in creating those. So what can we do differently as the people reviewing or making judgments based on that? What other information is important to paint that picture? So you will have to provide that information, and if you want to be engaged in improving fair housing in the real estate industry, then read up on those issues. Read up on how school ratings have the same kind of implicit bias that we just mentioned, and what we can do as practitioners to better educate our consumers about the reality of schools and credit and ability to make payments.
Excellent. Excellent. So I want to talk about fair housing, but first I just have to say this comment that came in from the official HAR Facebook page, and that says, we always follow your advice, Grant. So we're at least following your advice.
Okay.
Yeah. So as we have stated, April is Fair Housing Month. Can you tell us a little bit about the importance of fair housing in 2021? Also, where can members get better educated about fair housing?
Sure, I'll start if that's okay with Grant. So the fair housing is important and has been important every year for real estate, and it's a more emphasis might be on it this year because of the events of 2020, because of the awareness that people are open to learning more about what happened and how segregation was perpetuated and still exists today. And as a responsible advocate for home buyers and sellers, it's kind of our duty to understand where we've been in order to know where we want to go. So we at NAR are putting a huge focus on that awareness and that education. And if you visit our website, that specifically the link about April being Fair Housing Month, we have a number of book recommendations, podcasts, videos, activities, and other things that brokers can do, agents can do, brokers can bring to their firms, associations can do, to really shine a light on what's needed, where we still need to, where we've been, and where we still need to go. So I highly recommend that page as a jumping off point for your fair housing journey. Two good recommendations here. First, The Color of Law by Richard Rothstein. Every realtor should read that because it provides a base knowledge of how government policies, some association policies, and other societal influences have impacted segregation as we know it today. And then also check out our new fair housing tool called Fairhaven. It's a interactive experiential learning tool that takes you through as a consumer or as the agent or broker, takes you through real life scenarios that are gleaned from actual events, and lets you play the decision maker and learn in that multimedia environment. It's really cool. We've gotten great feedback. It'll take an hour of your time, and it's just well worth the effort.
Excellent. Alverna made a comment. I have my copy, and we actually had Richard Rothstein on this program last year. We can post a link to that interview. Excellent interview with him, and he just shared so much information. And of course, we definitely recommend that you read his book, The Color of Law. We did have I believe, and I may have missed it, but did you mention that you have a webinar coming up, Fair Housing on April 15th?
Yeah, no, thank you very much. Yes, we have a webinar that I highly recommend all members attend. April 15th. We shared the link. I think we'll share the link in the post here to sign up, RSVP. It'll be on Facebook Live too. But past, present, and future of fair housing, a really good hour on what we as realtors can do to better the fair housing for all consumers.
Excellent.
I think it's so critical, Christina, for licensees to just remember their role, whether on the buyer side or the selling side, that, you know, your seller or your buyer may not be as aware of these issues as you should be. And if they start to conduct themselves in conduct or words or mannerisms that touch at the chords of fair housing, you need to say something. You need to stand up. You need to educate them, help them through the process, turn somebody around, and turn them into fair housing advocates. If you're in that situation, whether, like I said, on the buy side or the listing side, you still have a role. Your antenna should be up and be sensitive to conduct by the buyer or seller that might be in violation of the Fair Housing Act.
Absolutely. Your clients just may not be aware. Yeah.
And that's not an altruistic event. You know, complying with fair housing is not just because it's the right thing to do. It's good for business. It's good for home buyers and sellers to make their properties available to all people. And for you as practitioners to facilitate that is good for the bottom line.
Very good. We had a question come in about intermediary. The question was, Kathy asked, how does an individual broker working alone show and sell a listing and follow the law of intermediary?
Read it, follow it. I mean, it's a very unique statute that we have here in Texas. It works quite well. There's very specific bullet points in your listing agreement, or you can look it up just generally. but I mean, it's easy to follow, and if it doesn't fit your situation, then you can't use it. But it's purely statutory, so it's a checkpoint. You read it, you follow it, you abide by it, and that's, I don't know, I'm not sure how much more I can add to it than that.
Okay. I'm about to ask two lawyers an opinion here, but Kathy said, why don't we see more equal housing logos on real estate for sale signs? Do you think there's any reason that doesn't seem to be a trend as much as it once was?
I think that's a really good question. I hope that it's not intentional. I would guess, my opinion would be that it's not intentional. Maybe the Fair Housing logo needs a facelift. We have a lot of great social media assets that we've created for Fair Housing in the That's Who We Are campaign. So again, if you go to nar.realtor or That's Who We Are, letter R.realtor, you can access all of our Fair Housing social media assets that you could put on your signs and that you can incorporate into the social media or print advertising that give a fresh face and new messages around fair housing.
Excellent.
If you want.
Very good. So are there any other messages, any thoughts that you want to share with our members today? We can start with you on this one, Grant.
Well, kind of back to more of a local thing is that most of our members know, but if they don't, that TREC redid the 1 to 4 family form contract, and they did other contracts too. That would be the most used one. But so you need to be aware of that. Starting April 1, you have to use the new form, and the new form changes language and application of earnest money and option fees, leases, fixture leases, oil and gas leases, or regular residential leases, that being disclosed in the contract, and also the conveyance of smart devices or the codes to smart devices. So that's all in the new contract. The option fee and the earnest money is probably the most critical thing that's changed on how that is to be done. You can go to TREC and actually print out or look at it online, the differences or the changes in red and blue and so forth, so you can see them specifically. But either way, you need to reread the contract and become familiar with the new language that's in the TREC forms, not just 1 to 4 earnest money, but all of them in relation to conveyance of a property.
Very good. Katie, I want to get some final words from you, but I do have a question that just came in that I think is we should definitely address, and that is, can a seller refuse to show their home to anyone that's not vaccinated?
Good question. So a seller has the right to, and Grant, please feel free to disagree with me. But the seller does have the right to control the environment of their home and who comes in and out of their home. When the seller is going to require the listing broker to ask about that information, the listing broker needs to really ensure that they have a strong policy in place for handling that type of medical information, that personal information. We have a lot of guidance on showing guidance for it related to COVID-19 on our website, nar.realtor/coronavirus, that touches on this specifically. But it boils down to almost everything we've talked about today is that if you have a policy, it must be applied evenly and equitably to every person. So if you're going to require it of one, you have to follow these same procedures and processes that you would follow or ask of any other potential viewer of the home.
Excellent. Grant, did you have anything you want to add?
Yeah, she said it perfectly. And so my advice on that is don't do it. Don't ask. Don't, just move on. And because you don't want to be accused of using that as a pretext to denying somebody access to your property. So we've all made it this far, and real estate seems to have done quite well during the pandemic without such a rule or a policy. So I don't know. I would be careful about instituting one at this point.
All right. Excellent advice. Thank you both. So Katie, any final thoughts for our members this morning?
Yeah, I would just say, first of all, congratulations to you who decide to wake up on a Monday morning and engage in risk management legal advice to start off your week. You are special people, so thank you. We at NAR just really do live to serve you and to make you successful, and we know that you live to make consumers successful. So please, when you need a resource or have a question, do not hesitate to reach out. NAR.Realtor, me specifically, will get you the resource you need. But my last request is to start bragging about yourself a little bit more. Start promoting what you do, what value you bring to the transaction, what services you provide, and how you get compensated. Making that information crystal clear in listing contracts and buyer broker representation agreements is going to serve you well, and certainly going to serve the consumers well too. So please start doing that.
Very good. Well, thank you again both for your time this morning. This has been very helpful. A lot of thank yous coming in from our members in the comments as well. So that is it for this Member Focus Monday. But next week, we will be joined by our brand new HPD Chief of Police, Chief Troy Finner. We're very excited to get him as he was just sworn into office last week, I believe. So it should be an exciting episode about crime and community. So thank you all. I hope you all have a great week. We'll see you next time. Bye-bye.
Bye.
Bye.